Dear Holy God, we thank you so much for this blessed Sabbath day. We thank you for the week that you've brought us through. You've fed us, you've guided us, you've protected us. You've heard all our prayers, and we give you thanks and praise for that, Lord. So please be with us now. And as I present this presentation today, Lord, that you'll be with us, that I'll have a better understanding, and everyone will, after this, and that we'll continue to improve on our learning, Lord, so that we can be the people that you want us to become. So please continue to bless all those that are here and those that are not as well, for whatever reason. We pray we'll have a blessed Sabbath, because we're all spending it with each other and with you. And we give you thanks and we give you praise in and through our beloved Saviour, always to your great honour and glory. Amen. Right, let me see, I've just got to get this up and running. Just bear with me, I'm just going to get the presentation ready now. Okay. What happened to that? Oh. For some reason I can't get. What's it done this? If I can zoom. Oh, that's it. Yeah. Just come. Can everybody see the screen? Or you can just say yes.
Yes.
Thank you. Right, okay. Today we're going to be doing part 2 of the Federalist Society. I've done a part 1, so we're just going to carry on from part 2. Right, can somebody read what's on the screen, please? Anybody?
I'll read it, Debbie.
Thank you, Emma.
Originalism. Constitution interpretation central to the influence of the Federalist Society itself and the network has been the ability to insert its preferred method of constitutional interpretation, originalism, into the mainstream. Originalism as fully articulated legal theory, had not yet been conceived prior to the 1980s. It was not until 1985 that the name original intention was given to the ideas being expressed by conservatives as they openly and frequently attacked the jurisprudence of the Supreme Court in the civil rights era. Thus, the principles of originalism developed throughout the 1960s, 1970s, and into the 1980s as conservative opposition to the Supreme Court's jurisprudence.
Thank you. What do you get from that? What we can sort of glean from that, it's that we can, especially the third sentence, where it's got the Federalist Society inserts its preferred method. So we know that due to their influence, this originalism is their preferred method of interpreting the Constitution. What else do you get that from that, Emma, or anybody else?
Okay, so originalism is their preferred theory over any other kind of legal way of interpreting law, is it? Or way of interpreting the Constitution, way of interpreting the Constitution when it comes to law.
Yeah.
Fully articulated legal theory had not yet been conceived prior to the 1980s. So this term wasn't really used prior to the 1980s. Although it seems that they are attacking the principles that were
there before
in the civil rights era. So it's kind of backlash, it seems, from the civil rights movement.
Yeah,
that they want to go back to originalism to combat that, to use those arguments against civil rights.
Yeah, thank you, Emma. What I was looking at, I was thinking to myself, well, if originalism was the preferred method that they want to use now, what was the method that they were trying to use then? I was trying to look at all these different methods, and when I tried to look at them, I sort of found there was historical, textual, structural, prudential, traditional, moral. So I'm just going to sort of go over, just a couple of those, what they mean. So historical is a judge that looks at the historical content of when a given provision was drafted and ratified to shed light on its meaning. And then I'm going to look at textual, a judge looking into the meaning of the words in the Constitution, relying on common understanding of what the words meant at the time the provision was added. And then I'm going to look at structural. I'm not going to look at all of them, but structural, a judge infers structural rules, power relationships between institutions, for instance, from the relationship specifically outlined in the Constitution. So that's naming just three of what other sort of methods that were probably looked at. So we're going to look deeper into that as we go into the study as well. So any questions before we go on? Okay, does anybody want to read the next one for me, please? I don't know who's there. So Susan, would you like to read what's on the screen? That's if you can see it. Is anybody there that would like to read the next one?
Sorry, it's on my phone, so it's ever so small.
Do you want me to make it bigger, Susan? I don't even know if I can make it bigger. I don't think I can make it any larger from where I am at the moment.
It's okay, don't worry.
Oh, all right. Okay.
Yeah, because
Are you actually reading anything, Susan? Because we can't hear you.
no.
You can't read it. Okay, I'll read it. Increasingly, critics of the courts began to invoke strict construction, history, and the framers' intention in reactions to the decisions upholding affirmative action. Affirmative action is a set of procedures designed to eliminate unlawful discrimination among applicants, remedy the results of such prior discrimination, and prevent such discrimination in the future. So Conservatives needed an idea that could provide intellectual legitimacy for those areas where Conservatives thought that the courts should not simply defer to the elective branches of government, as well as those where it should. While Conservatives were becoming increasingly interested in, for example, putting teeth in the Fifth Amendment's takings clause, judicial restraint pointed in the opposite direction. Even more important, Conservatives needed an idea that could be taken seriously by legal intellectuals and the profession as a whole, a task for which judicial restraint did not measure up. Desegregation measures abortion rights and the rights of the criminal accused. So it talks about, in this particular slide, it talks about strict construction. Strict construction is an original intent. An original intent is a theory limiting interpretation of legal and constitutional language of the literal meaning of this language and the time of passage. So this theory contrasts with a loose construction of laws, which allows broader discretion by judges to determine intent in legal language. And of course, we've got strict construction and we've got loose construction. What's loose construction? So the opposite of this. So loose construction is of the Constitution, sometimes also deferred as a broad construction, by definition, is a constitutional interpretation that requires an analysis of history, scientific findings, or political circumstances to be applied to a legal case alongside the ruling of the Constitution. Loose construction often does not include a single philosophy, such as the only examine the Constitution's text, as found with strict construction, but instead incorporates multiple aspects of interpretation to understand a specific circumstance. So this is used by individuals who believe and advocate for the Constitution being a living document, being that it should be interpreted and applied circumstantially based on historical and social findings. So the exact causes or events of the time period may not reflect the practices of another time period, meaning that older rulings or precedents may not be best applied to a current situation. Did everybody understand that one?
I think that was quite a lot there.
Yeah, there was two. So does anybody want to ask any questions, or do you want me to go over that again? Or what did you understand or what I said, or anybody for that matter?
Can you kind of break it down, Debbie?
Which breakdown, which part? Sorry.
Well, starting from what you read.
Well, there's two constructions: strict construction and loose construction. And it was telling us, it's explaining it to us, the two, what the courts were wanting at the time. They want the strict. They were going for ruling for the strict construction. I just explained what strict. Oh gosh, I can't get my teeth around that. Strict construction was. Then to opposing to what loose construction was. And how,
can you kind of put it in your own words?
well, I did.
Oh.
I did. That's what I mean. Believe you me, it's more complicated than this, and that's what I did. I broke it down into my own words.
And just looking at a definition of strict construction, I think it says strict construction requires the judge to apply the text only as it is written.
Right.
Once the court has a clear meaning of the text, no further investigation is required. So this is a very originalism, thus
Yes.
the Lord, as it's written, kind of with
Yeah.
no leeway. Whereas the loose ones will look at the context and say, well, let's draw out the principle. That's what I'm getting in simple terms.
And also plus they're looking at it differently on this one. They're looking at it. They're making it, which should be just like the Democrats are doing. They're making it a living. Where do I put that now? A living document, meaning that they're going to interpret it and apply it to the historical and social findings at the day, which is, for me, is the correct way to look at things, really. Does that make you understand it more, Cedric?
I think I'll have to probably go over it myself too.
I mean,
It
what
was very wordy.
as it was, I mean, it's easy, and I mean, what I could do, I can actually send you something over later if you want.
Yeah, that would be great. Thank you.
I'll send you something later because it's hard to sort of go, too deep.
Question about that slide, Debbie. I don't know if you were going to touch it or not. I don't know whether it's important, but the Fifth Amendment takings clause, I don't know what that is, but presumably it's something, I'm not sure. Do you know what it is?
I haven't gone deeply into that at the moment.
No, that's fine. They wanted to put some teeth in it, so presumably they wanted to use it to their own ends.
Yeah, I think that's something I can bring out. Okay, we'll go into the next one. Can anybody read the next one? CG, could you read the next one for me, please?
Yeah, is this strict construction?
That's the one.
A strict construction was not defined but recognized as a position of opposition to the Warren and Burger Court's jurisprudence grounded in the understanding of the constitutional framers. Both Richard Nixon and Ronald Reagan elevated the courts to a priority on the conservative agenda, campaigning for strict construction, law and order, and judicial restraint. These phrases guided conservatives as they developed a more sophisticated legal philosophy in the 70s and 80s.
Yeah, thank you, Secretary. So when we read that, we're going to, I mean, it talks about, we've already discussed what strict construction is. But we can also, I'll also go into deeper what judicial restraint. Does anybody know what judicial restraint is? Or what do they think it is? If not, I can actually explain that to you now. So judicial restraint is a procedural or substantive approach to the exercise of judicial review. So as a procedural doctrine, the principle of restraint urges judges to refrain from deciding legal issues, especially constitutional ones, unless the decision is necessary to the resolution of a concrete dispute between adverse parties. So that's what judicial restraint is. Okay, so we'll move on to the next one. Can somebody read this one? The next slide for me. Curtis, are you there? I'm not sure who's there actually. or anybody who they can see this slide?
I can read it, but I'm not sure if I'll be able to explain all of this at the end. But
Right.
I can go
Someone.
ahead.
No, you go ahead. You go ahead.
A 1971 journal article by Robert Bark is viewed as the origin of a framework for organizing these loose ideas into a principle of constitutional interpretation. Barks called for a neutral principle to determine a valid theory for constitutional interpretation, laid the groundwork to guide the development of a formal concept of originalism. It was not until 1985, in a highly publicized speech to the American Bar Association, that Attorney General Edwin Meese's announcement that the Reagan administration legal policy had been and will continue to be a jurisprudence of original intention gave a name to the developing originalism, an idea that had been either created or resurrected, depending on one's point of view. In the 1970s, seemed to admirably serve both goals, starting with Robert Bark's 1971 neutral principles and some First Amendment problems, and accelerating with Raoul Berger's government by judiciary. Scholars critical of the Warren Court began to develop a critique of the courts that rested on an essentially historical methodology, arguing that the legitimacy of the judicial role rests on the original understanding of specific constitutional provisions. Until the scholarly interventions of Bark, Berger, and their successors, conservatives, lack an intellectual framework in the law that was as rigorous as those they had developed in political philosophy or theory. Justice Brennan's subsequent counter to Mises' view kicked off the great debate over the role of the Supreme Court and constitutional interpretation. That was a lot.
Thank you very much. Thank you, Samway. So the thing is, who is Robert Bork? Robert Bork was a lawyer, and he was the one who wrote this article. He was also working in the Reagan administration. So does anybody want to ask any questions? I think this is quite... Does anybody want to ask any questions about this particular slide before we move on? Does anybody understand or remember who the American Bar Association? So the American Bar Association that it talks of there is a voluntary bar where people meet, and it's the largest sort of bar in the world. It has about 400,000 personnel, and it's basically made up of lawyers and law students. That's what the American Bar Association is. And so we did speak about that in the first presentation. If not, we'll move on.
So Debbie, is this just saying, I wanted to kind of summarize it, that Robert Bork is the one in 1971 who started to give a name to this theory, really?
He did, yeah.
The concept of originalism.
Emma, can you speak up, please?
Oh, I'm saying, is this can you hear me all right?
Actually, are you using your mic? I think when you got use your mic, Emma, we can hear you clearer.
Use my mic. I'm just speaking into the laptop. Maybe it's not loud enough. So I'm saying that the summary of this is really that it was Bork in 1971 that starts to give a name to this theory or form this theory by saying we need to go back to the original intention. And jurisprudence is just the structure that they decide to use to interpret the theory, isn't it? It's their framework, basically. So he's saying to go back to the original, using that word originalism. And I think it gave it force because they now had some name to call it. So it's kind of like it took off from their original understanding. And it was a backlash to the Warren and Berger court, which was a Supreme Court which was more liberal. And when you said about judicial restraint, is the belief that justices should not seek to legislate from the bench. So this should be left to the legislature and the executive. So there's this debate about how much power the Supreme Court has or courts have to legislate from the bench of the judge, I suppose. Is that right? Is that how you see it?
Yeah.
So that then greater stress should be placed on ruling of the lower courts, and they should be allowed to make their decisions rather than to the Supreme Court to have so much power. So there's this debate about the Supreme Court having so much power.
Yeah, that's it. Thank you very much, Emma, for breaking that down for me. That was really well put. Right, we'll move on to the next one. Can somebody read the next one for me? Finally read that one if they can see it, okay? Anybody who's there?
I can read.
Oh, Magda. Hello, Magda. Yeah.
Hi. Conflict over the role of the Supreme Court in American constitutional system is as old as the Constitution itself, beginning shortly after the Constitutional Convention ended and the state ratifying conventions began. However, unlike the debates of today, the central conflicts were over the Constitution's creation, structure, and distribution of powers. The Anti-Federalists and the Federalists were sharply at odds over the powers vested in the new federal government, including those granted to the one Supreme Court created by the Constitution. The power of the Supreme Court divided Anti-Federalist advocates and Federalist adherents. The power of the judicial review itself, and who is the final authority on the law, remained in dispute even after Marbury versus Madison appeared to provide an answer. Rather than disagreements over interpretative methods, the debates concerned the fundamental questions of governing, the distribution of power, and the structure of government that had been created. The question was not how, but rather who should interpret the Constitution, and even if judicial review itself is the rightful power of the court. These differences that divided the Federalists and the Anti-Federalist groups evolved into the United States' first two political parties, the Federalist Party and the Democratic Republican Party.
Thank you, Magda. What do you understand from that, what you just read?
I will have to reread it.
Oh, yeah, little by little. Little by little.
Maybe someone else wants to break it down.
Okay, does anybody else like to break this down? What I can add is that the anti-federalists at the time in the 18th century, we're talking now, they didn't want a constitution because they felt it would give the central governments more power, and they favoured a strong sort of state government and a weak central government. So that was what was going on in the 18th century. I'll talk about later on in there where it talks about Marbury versus Madison. Basically, when I looked into that case, this was a landmark, a landmark in the US Supreme Court. It was a Supreme Court case that established the principle of judicial review in the USA. So that meant that American courts now have the power to strike down laws and statutes that they find to violate the Constitution in the USA. So that's what that Marbury versus Madison was all about. And we know that. Sorry, who was that? Sorry.
Yeah, it's me. Hi, Debbie.
Oh, hello, Curtis. Sorry.
So in that Marbury versus Madison, where you have the Federalists and the Anti-Federalists at odds,
Yeah.
maybe perhaps you said it in your description now, and I might have not heard you, but what was the position of the Federalists and the Anti-Federalists in that case? What did they want? What was their objectives?
Anti-Federalists didn't want a constitution that they felt that was going to give the central government more power. That's what they didn't want. And so what they liked and what they wanted was a strong sort of state government and a weak central government. So that's what the controversy.
And they were on the, I don't know who was the defendants there, Marbury. They were on the side of Marbury.
I know that Madison wanted to protect individual liberties.
Okay.
Yeah, if that made any sense.
So Madison was the Anti-Federalist.
Yeah.
Assuming that's James Madison.
Yes.
Okay.
Yeah.
Makes sense. Thank you.
Okay. Anybody else want to ask a question? Right, okay. Can anybody read the next one, please?
Well, Katie, sorry, you just said that makes sense. Can you explain again? Sorry, I don't know if I followed that a bit.
I was just asking Debbie, in that case, Marbury v. Madison, what was the dispute and who was involved in that case? And from what I understood, what Debbie explained to me was that James Madison was an anti-federalist who was in favor of separating the powers of a federal government, i.e. not centralizing power in the Supreme Court, and Marbury were on the side of the Federalists, who were saying we need a federal government, so take it away from the states and centralize power in a federation. I think that's what Debbie was saying, but yeah, go on.
Okay, so if the power is centered in the Federation, that means they're giving more power to the Supreme Court as well, by default. I see, I'm asking, I'm not sure.
Yeah, I think yeah, I don't think, I'll have to take that back. I don't think that Madison was an anti-federalist. I think he was a federalist. He was an actual federalist. That's somebody else I'm thinking of.
Okay.
Yeah, sorry about that. Okay. Can somebody read this next slide, please? Can somebody read?
Hello.
Hello.
Yeah. This was later refined in a very useful way to original meaning, jurisprudence. But remember, at this time, the stuff of debate was still kind of the old Nixonian terminology of strict constructionism and law and order, jurisprudence, language of interpretivism or textualism or original meaning, jurisprudence. These things were all aired and the subject of a great deal of discussion at Federalist Society meetings.
Thank you. Does anybody want to? I mean, that's quite self-explanatory. So we move on. Would like somebody else like? Sorry,
Sorry, I don't understand that at all. I don't think I got anything from that.
this was to do with this one. If it was talking about that, and then it goes on to this.
Okay, so what is it? I remember this time.
Yeah. Okay.
So are you saying with this that the history basically is that this has been going on for a long time, this debate between how to interpret the Constitution, because it's connected to how much power the federal government has over the state governments, and how much power the Supreme Court has.
Yeah. Yes, definitely, because it was a discussion of the Federalist Society. Is that okay? Right. Does anybody want to read the next one, please? Does anybody up there want to read the next one, please?
Yeah, I can read it, Debbie.
Thank you.
The interpretive method was not the concern because most agreed with the legal theory of the times, which viewed judges as acting mechanically and neutrally to simply apply the law as written to the facts of the case. There was no perceived danger of a judge's interpretation in line with his preference. For judges may truly be said to have neither force nor will, but merely judgment. That is, they merely declare the law. This theory, expressed by Hamilton in the Federalist, number 78, was generally accepted by both Federalist Party and the Democratic Republicans. Therefore, constitutional interpretation simply followed a plain meaning rule articulated by Chief Justice John Marshall, in which the spirit of a constitution is to be collected chiefly from its words. Plain meaning was derived from a common sense understanding, according to the sense of the terms and the intentions of the parties.
Thank you, Curtis. What do you understand from that slide, please?
That in this time period, the problem at hand wasn't necessarily how the Federalists and how the Anti-Federalists interpreted the Constitution. It was, just going back a slide to include that as well, or 2 slides. The problem between the two parties was where power should reside and who should hold power. And so it's saying here that everyone generally agreed with how to interpret the Constitution, and that it is this, everyone adhered to this plain meaning rule, this idea that you gain what is said from the words. Yeah, so that's, I don't know how true that is, but at least this is what the author of whoever wrote this is saying, that the contention at the time wasn't necessarily about interpretation, but was about power dynamics.
Okay, lovely. Thank you. I would say that. Thank you very much. Does anybody else want to comment on that before we move on to the next slide? Thank you, Curtis.
I was picking up that they see judges as non-biased, that they don't have a view of their own. They're supposed to be without preference and just interpret the law as written and be that sort of like neutral. It's used the word mechanical and neutral, which we know is not true, but people saw it.
Yeah, thank you very much, Emma. Emma, can you read the next one, please?
Yeah. Originalism, the idea that judges simply discover the law without preference or context, was challenged in the late 19th century, most notably by Justice Holmes, and further contested in the early 20th century by the appearance of the American legal realist. In contrast to the prior legal formalism, legal realism posited that judges in the process of interpretation do make laws and look to norms in their current context, rather than at the time of the original authors. In this way, the court has shaped the living constitution to the needs of the day as it felt them. This jurisprudence of a living constitution gained adherence on the Supreme Court in the early part of the 20th century by both legal progressives and legal conservatives. It was in reaction to the idea of a living constitution and the belief that judges were construing new rights beginning in the late 1950s that conservatives began to articulate the features that would develop into a theory of originalism.
Yeah, sorry, it really explains it very well, that does, doesn't it?
Yes, I think that's not too hard.
Yeah.
So they basically, just going back, the idea that judges simply discover the law. So they thought that judges just basically gave the law as it was written, but then they challenged that concept, it seems, in contrast to
legal formalism.
And this idea of the living constitution to combat that they moved with the times, that the constitution is living, that we have to apply these principles that we see in our own context.
Yeah.
And it was becoming popular in the early 20th century by both the progressives and the conservatives. So they were in agreement at the early part of the century that this makes sense, that we interpret it in terms of today, that the needs of the day be felt. So they were all on the same side at that point. So it seems that it makes a distinction here in the late 1950s, as we said already, with the civil rights movement, that there's now a reaction by the conservatives who don't like the civil rights movement and are trying to find legal ways, I suppose, or what's the word, academic ways to argue that this is not the right way to see the Constitution now because we don't like what it's saying to us.
Yeah, yeah. Thank you. very much.
There's a sentence in there. Legal realism posited that judges in the process of interpretation do make laws. And I think it was during part 1 of this, Debbie, where my dad had asked the question, that Congress are given the task to make laws, and then it's the Supreme Court's job to interpret the Constitution. And, my dad questioned whether that's fair or not, or whether that makes sense. And just in this sentence, it's pointing out, that when someone interprets something and they say, this is the interpretation, and then they pass it down, as much as you say, okay, it's just interpretation, you're inadvertently making a law, if that makes sense. So it's like the Supreme Court say, okay, Congress, you make laws, but if we don't like the laws that you make, you can't make those laws. So it's like, who actually makes the laws?
Are you saying by that whoever interprets them, the way they interpret them, will determine how they're practically applied, which means that you have made that law in practical terms?
Even, yes, practically applied, but even just like deciding whether a law is lawful or not based on the Constitution, that law can be stripped. So even taking away from how that law is applied, that law can just be said, okay, yeah, let's take away that law because it's unlawful, dependent on how the Supreme Court interprets the Constitution. So who's really the overriding say, the judge and the juror over who makes laws?
Right, okay. Right, that's a question mark. So can we move on to the next one?
Just before you go on to the next one, just leading on from what Curtis is saying, I'm just trying to get really how the system works as we know it right now, because as Curtis was saying, the Congress or the Legislative Assembly makes laws which judges have to, work from. And then if the case goes higher to the Supreme Court would look at those judgments made by the judges or wherever it's coming from, and then look at the Constitution, what the Constitution has to say about that. And then they would give their judgment based on what the Constitution says about either a past judgment that has been given from a lower court or from a case that has come to them. So at the end of the day, you have this situation where the Supreme Court is like the overruling body of all things, yet they are unelected. Doesn't that make this whole thing rather strange?
You talking about the system?
Yeah.
It still has to go to the executive, doesn't it? To be verified and accepted overall. But do you mean the way that it goes through the judicial, the Congress? You talking about
because Congress actually makes laws, and Congress is the representation of people. So I'm saying in the full circle of this whole thing,
system, yeah,
the people's views are not really considered. At the end of the day, it's what the Supreme Court says, and that Supreme Court is represented by people who are not elected to office.
No, I see what you mean now.
Yeah.
I don't know what, does anybody, I'll leave that open to anybody to comment. I don't know what to comment on that one.
Brian, could I ask a question?
Yep.
You suggested that the system that they've got, and I think I didn't quite catch everything that was being said. I think Curtis either asked a question or made a comment about it, and then you've, I think, ended up agreeing with him. If the way you suggested the system currently works, is that the Supreme Court, either inadvertently or by design, I don't know which, ends up essentially making law because of the way they interpret it and they apply it. And there seems to be the inference that there's something fundamentally wrong with that way of doing things, if I understood the point that was being made. What other ways what other ways there to do it? How would we do this thing? Because if Congress makes law and you go to court, obviously you have the judiciary or a judge sitting there, and you've been found or been accused of some kind of crime, and you're going to go to court. What are they supposed to do? There's a law that says you can't do something, and obviously they're going to have to make some kind of judgment on that. So whether or not it's the Supreme Court or a lower court, the judiciary itself, how is the system supposed to operate? I know perhaps you were even asking that same question, but doesn't it work exactly the same way in the UK and in fact any modern democracy? It works the same way. The government itself can't end up being the authority of applying the law, can it? Because when you're a criminal or you do something wrong, you don't get judged by the government, you get judged by the judiciary, the court system in any country, I think. So why is America any different than any other place?
What my point or bone of contention is the Supreme Court itself. Those that are put there to do the job of the Supreme Court are people that are not elected. I think there should be a better system of putting people into the Supreme Court than the one that is there right now, because as we can see, it's very flawed the way the two main political parties are operating it.
Okay, so it's the fact that not the fact that the way the system is set up, it's the fact that who those judges are and how they're selected. It's the selection process of judges you're complaining about or critiquing.
Yeah, more that than anything else.
And do you think that's different to any other modern democracy?
I don't know what the other systems are in the world, to be honest, but I'm just looking at what we're dealing with and I'm saying, yeah, hasn't really worked well.
For instance, in Israel recently, you know that the government has tried to basically either curtail or hinder in some shape or form the Supreme Court, and there's been a strong backlash for that because they're saying they're politicizing the Supreme Court by stripping it of its powers. And I'm pretty sure in the UK as well, judges, and we have our own Supreme Court, but judges at any level are not voted in by the people. They're just two examples, and I haven't spoken about the Israeli one in any detail. But I don't think America is unique in that the way judges are appointed is not by election. I'm not
Perhaps
trying. I'm not trying to defend the system in America. I think it's not very good at all.
Mm.
But I'm trying to think of if we were to start with a clean sheet of paper, how would we do it, or how would you suggest it might be done in a more egalitarian, a fairer way?
perhaps those judges are maybe second-handedly voted in. What I mean by that is because it's the president who appoints those judges and appoints Supreme Court justices, and presidents are elected by the people. And aside from how in America they have popular vote and the other way of doing things, aside from that, we'll just say that the presidents are elected by the people. And so the people are saying to the president, okay, we are giving you and your ideology the freedom to elect judges who reflect what we've voted for. So it's like second-handedly, those judges are elected by the people. Maybe. I don't know.
Mm. Did that answer your question, Brian?
Yeah, the machinery in my head still ticking away. I'll come back. You carry on.
Just one final comment. I think Brian already knew that. I think we all knew that. That's not a surprise. It's not as ugly as Curtis just suggested, because there are hearings where there's cross-examination going on, etc., etc. It's not just the president has a free choice to do what they want. But my question was, how else would we do it? I know the idea is that the people have voted for that Supreme Court judge by proxy because they've handed power over to the government. But those judges have to be selected in some shape or form. Would we feel safer that the judges themselves voted for those positions as opposed to politicians? Because you've only got three choices. You either do it by direct vote from the people, you either do it by the government, which nominally is selected by the people to do this work on their behalf, or the judges themselves do it. And if we were to say the judges can do it, the argument that Brian is making that these judges aren't even elected would be even worse, because at the moment, at least the ones that are selected by elected people. If it was the judges that did it, it would be a closed loop and it would get even worse, wouldn't it?
Yeah.
I agree the system, it doesn't work well and it's not good, but I struggle to think of a better system.
Mm. Yeah.
Would we say that the system had worked up to now, or at least up to the last 50 years or so, and to a degree? I mean, I know you could argue that it's never worked. Yeah, Natalie's saying balance in the background. Yeah, it's the balance of it, that people have to be accountable to other people. Otherwise, you've got that danger of the dictator or one person doing what they want. And it's only in recent years, with all the polarization of beliefs, I suppose, and bringing that into the court, that has imbalanced the court and made it go this, as abused the system, really, that people didn't abuse the system before this in such a bad way, because they were in agreement at the turn of the century. We just read that about the way to interpret the law. So it's
perhaps a little refining would help the situation. And for now, I'm just thinking, the thought that crossed my mind is, I think limit the time period that a Supreme Court judge is in the chair. This for life business, nah.
Yes, that would be one way. And there's a question in the chat, Debbie, which Susan asked: is election and selection different?
I'll have to get back to that one. That's all right.
I think it. Well, I don't know if I give an opinion. I think it is. Well, I think by the way they were talking about this, that selection is done by a few people, by the president, for instance, and a few people in government. If you look at the Supreme Court, but election is elected by the people, like at a ballot poll. ruling. That's how I'd see the difference. Perhaps
Yeah.
it's just the amount of people involved.
Yeah, okay.
But
Okay.
the judges, there's a political bias in each one of them, isn't it? So how can they actually, I mean, look what happened. Is it Clarence Thomas or something, or forgot his surname?
No, that's
The one who, Anita Hill, I think, took to court. But he still stayed as a Supreme Judge. So there's just a couple of flaws there then.
what point are you bringing out, Cedric? Sorry.
Sorry?
What point were you bringing out? Sorry.
I was just bringing that out to say that, the Supreme Court, they are, it's not in a way 100% fair, I think, because everybody comes with their own political biases and prejudices, and the law is not. I'm talking about the law in the case of Anita Hill and Clarence Thomas, I think. I don't know if that's his surname. When she took him, she complained about sexual harassment, and he, the tables were turned around in his favor, and he still stayed on as a judge. And that's because everybody, all the other judges, I think, voted for him to stay on.
Right, okay. So did somebody want to say something then? Right. Right, okay. I'll have to come back to you on that one, Cedric. Okay, we'll move on to the next one. Can somebody read the next one on the next slide, please? Can someone please read the next one? Magda, would you like to do that?
Yeah, I can. Mercer's 1985 speech to the American Bar Association was followed by the same speech at the Federalist Society, DC Lawyers Chapter. Mercer's meaning was clear. DOJ, legal policy, will endeavor, I don't know how to pronounce that. Thank you. To resurrect the original meaning of constitutional provisions and statutes as the only reliable guide for judgment. The clear implication of the language of resurrection was that the court had strayed far from the original meaning that the authors intended and instead were substituting their own meaning or preferred social values. Mercer's speech articulated the position of movement conservatives on constitutional interpretation and claimed anything other than this interpretation was an illegitimate insertion of subjective social values. This early version of originalism was designed to promote judicial restraint and criticize the judicial innovations of liberal judges in the 1950s, 60s, and 70s.
Thank you, Magda. Does anybody understand this slide? Or what do you get from, or what do you understand from this slide? Curtis, do you want to give your...
Okay.
Oh, Brian, sorry.
Yeah. Mizi's speech, he obviously was a conservative, and his view on constitutional interpretation was that you have to stick to the original writing of that bit of law, whatever it was. And as this was being read, and I'm looking at it again now, and I'm saying, okay, this is the problem that we have even today, that we have moved on from the 1950s, 60s, 70s. Life has changed in so many ways, and people are seeing things differently. And if you stick to how things were written then without considering social issues, the time that we live in, and all these things that matter to human beings living in this day and age. And if you stick to what was then and try and apply it now, you're definitely going to have problems. And this is the sort of thing that we're having right now in the USA, as far as one example would be gays and lesbians.
Mm.
So yeah, definitely that's what I'm seeing here, that we're going to have these problems, and they're coming back again.
Mm-hmm. Does anybody else? Thank you, Brian. Does anybody else have any comments? Can somebody read the next one, please? The next slide. All right, I'll read this next one. The ideas that undergird originalism began in response to the Warren and Burger courts to express opposition to the court's decisions. Conservatives charged the court with straying from the original intent or original meaning of the framers and raised objections to decisions by calling for a strict construction of the Constitution to contrast with the flexibility that viewed in the current jurisprudence. So basically, originalism sort of became successful, like a successful political tool to mobilize conservatives in the electorate, and also to unite conservatives of different philosophical bents under the Federal Society. So it talks about the Warren and Burger Court. So the Burger Court advanced the Warren Court's privacy decisions to abortion. So in 1965, the Warren Court recognized a constitutional right to privacy in the Griswold versus Connecticut. So in Griswold, the court struck down a state law. Okay, does anybody want to comment about that, or can we move on? I've got the right page. Here we go. Does anybody want to read the next one, please? Coming to an end then.
Yeah, Debbie.
Yes, do you want to read the next one?
Over time, the debates within the Federalist Society revealed intent was problematic. The network members increasingly recognized the difficulty in interpreting a person's intent. The meaning of the text arose as an alternative method of interpretation introduced by then DC Circuit Judge Antonin Scalia at a DC meeting of the Federalist Society Lawyers Division. Original intent then evolved into original meaning. Original meaning brought with it a distinctively different conception of judicial restraint. Conservatives had long been calling for judicial restraint. However, the younger generation believers were not so inclined.
Okay, do you want to?
It seems that the Federalist Society was had division in itself about revealed intent was problematic. So this originalism led to looking at what the original text said and what the framers of the Constitution meant when they said that. So it wasn't just the words, it was the meaning behind it. So original intent then evolved into original meaning, which was problematic, because if you start saying what did they mean by that, you're going now into more of being able to come towards the left, I would say. Different conception of this. It means that now the court doesn't have that power to strictly interpret what's going on and say, well, thus saith the Lord in its literal sense, as we would say in the movement, perhaps. So conservatives want this judicial restraint. They want the court to have the power to to have more power, basically, but the younger generations were not moving in that direction.
Right, okay, thank you. Okay. Can somebody read the next one? Curtis, can I
You-
ask you? Oh, sorry, who's that? Sorry.
Yeah, they were
Yeah.
graduating.
Who's that? Sorry?
Brian,
Brian, do you want to go ahead?
they were graduating at a time when Reagan was in the White House, and conservative ideas were ascending. For them, this was not a time for judicial restraint, but a time for judicial activism. The founding generation of the Federalist Society worked to convince the older generation that the traditional conservative doctrine of judicial restraint had to be revised to suit current realities. What has been referred to as a new originalism, as distinct from the older version, developed in order to defend the innovations of an empowered conservative judiciary.
What do you understand from that slide, Brian, please?
Yeah, it's exactly what I had been talking about earlier on the previous slide.
Mm.
When it says they were graduating at a time,
Mm-hmm.
actually, who is that referring to? Who is they?
That was the what do you call them there? The students. The previous slide was talking about the students, the younger ones.
Yeah. So wherever these students were, they
Look.
were saying Reagan and the White House, their conservative ideas, they were against that. It was not a time for judicial restraint, but for judicial activism, meaning, we got to move on from the older ideas or the older generation, the traditional conservative doctrine,
Mm-hmm.
and we need to adapt and change, because what was doesn't necessarily apply. It's not applicable now.
Right.
Question to my dad. So is this slide, in context of the last one, is this saying that they need to move away from originalism to, we'll say, living constitutionalism, or is this saying that these people, founders of the founding generation of the Federalist Society, are trying to repackage originalism as something new? So they are trying to distance themselves from this old originalism and repackage it as what they're saying there as new originalism, distinct from older versions, and yeah, rebrand themselves.
Okay, the next slide will answer your question, I think, Curtis, if you want to read that. Yep.
Wait, sorry, what? Pardon?
I said the next slide will answer your question.
Yeah, I can read it. This is the one that we just read.
Yeah, this one here.
Okay. The younger conservative members of the Federalist Society were much more accepting of judicial activism as necessary, but only their type of activism. So this is the conservative members who were graduating, I assume.
Yeah.
They contended it was not judicial activism if a judge was returning to the original principles that were ignored by previous judges in their opinions, but still an exercise of judicial restraint. The old original intent and the old judicial restraint faded into the background as a new original meaning emerged and was paired with an updated judicial restraint armed with a justification to overturn previous decisions.
Does that answer your question?
It does kind of, but I have more questions. Which is, so from what I can see is that it's all talking about conservatives, whether old or new, they're both conservatives. But as I suggested, perhaps this is a rebrand. But what I don't understand is that the second sentence where it talks about them contending, they contended about judicial activism. Like, what do they mean by that? And what does this author or wherever this is from mean by a judge returning to original principles that were ignored by previous judges in their opinions, but still an exercise of judicial restraint? I don't understand that sentence.
Right, okay. New original meaning emerged and was paired with an updated restraint. Armed with justification to
Perhaps I can offer my
Yeah.
humble interpretation of that. They are saying that if judicial activism is actually a way they want to introduce that not only will follow what the old judges had passed in previous cases, they want to move on from there to say, look, if there were wrong judgments passed in the past, so we can be able to revisit those cases and overturn decisions that were made. You know, it's like they're going more right-wing than ever before. That's
So
what it seems to me.
past decisions made by conservative judges?
Yeah.
Okay.
Does anybody else want to comment about that, Emma? What do you see in this one?
I was trying to understand what judicial activism is. It seems that it's a philosophy holding that the courts can and should go beyond the applicable law to consider broader societal implications of its decisions. So we would say that was a more current, perhaps. They usually pit it against judicial restraint. So judicial restraint is sticking to the old ways of interpreting law in the traditional original context, originalism. But traditionally, judicial activism is a case that they don't agree with. Like, I mean, examples of it are Brown versus Board of Education and Roe versus Wade. So those are examples. They've been characterized as judicial activism because in those cases, the judges interpreted law in their current context and changed law that had been there before, massively. But now the right are using that, it seems here, they're wanting to bring originalism up to date in a more current context and call it judicial activism because they want to enshrine right-wing views more strongly than they do. So yeah, it's all originalism, like Curtis just said, it's all right-wing, it's all the same, which is not how I was reading it to begin with, I think. But these young Federalist lawyers are coming up and saying, we need to make this originalism idea more grounded, more solid by bringing it into the 21st century and calling it judicial activism and basically enforcing right-wing views in that sense. Or, yeah.
Okay, thank you.
I think,
So today the network has accomplished a sleight of hand. A call for judicial restraint came in handy for an opposition movement's attack on the perceived judicial activism of the Supreme Court. However, once in control of the federal government, Conservatives found that judicial restraint would not support an agenda to reverse decisions of the Warren Court and return to a pre-New Deal legal environment. So this agenda to radically change standing law would require overturning numerous precedents and thus called for an active judiciary, precisely what Conservatives had opposed for 5 decades. We're going to be looking about the Warren Court. I'm going to bring out what that was again. So the Warren Court was a period in the history of the Supreme Court of the USA from 1969 to 1986. So Burger succeeded Warren. These are Chief Justices. Burger succeeded Warren due to retirement. So the Burger Court is generally considered to be the last liberal court to date. It has been described as a transitional court due to its transition from having the liberal rulings of the Warren Court to the conservative rulings of the Rehnquist Court. So the court did not overrule any of the major precedents set by the Warren Court. So this point was recognised as the most important point in radical power. And Chief Justice Warren, his name was Earl Warren. So that court expanded civil rights, civil liberties, judicial power, and the federal power in dramatic ways. It had been widely recognised that the court, led by the Liberal bloc, has created a major constitutional revolution. The Warren Court brought one man, one vote to the United States through a series of rulings and created the Miranda warning, which brought an end in segregation and racial tendencies there. So they ended prayer in schools and included it in the 14th Amendment, and which it was incorporated in the Bill of Rights. Does anybody else want to make any comment about this particular slide before we move on?
Sorry,
So Deborah, go on.
can I just think? Oh, sorry, carry on.
No, it's all right, Brian, you go.
Oh,
I just wanted to inquire about the Federalist Society so I can just get things right in my head. Were they conservative? Are they conservative or liberal?
they're conservative. They're on the right.
Okay.
Right, yeah.
All right. Thanks.
Extreme. They're extreme conservative.
Yeah.
Mhm.
Emma, go ahead.
Yeah, so it seems from this slide that they used judicial restraint as an argument.
Yeah.
And then they realized it's almost like they had two steps to take. So they had to stop this liberal court. They had to stop these rulings that were pro-women or pro-black people, the civil rights movement. So because they were afraid now that all these people were being given power, if I put it in my language. But so they had to do that in two steps. They were saying this judicial restraint, we need to challenge them and say, you need to go back to the old paths and interpret the law correctly. You're doing away with the Constitution because you're not interpreting it in a right-wing way. You're not doing it in the original intent and the originalism and reading the words on the page and applying them. And then they recognize, actually, to undo a lot of this damage, we're going to have to be activists now, because that's not enough just to say you need to interpret each case that comes up in a traditional way. It's not enough to overthrow some of these things that have already been put in place. And in order to overthrow them, that last bit says, this agenda to radically change standing law would require overturning numerous precedents, which goes against what they say, because they're saying you have to build on what's already gone and we have to make the same decisions as we have in the past. And now they're recognizing actually these arguments won't work to overthrow these left-wing decisions. So now we have to be activists and say, actually, now we want to overturn the things that have gone in the past because we don't agree with them. So now we have to be activists, but we're going to be activists for the right wing. So it's more dangerous because it's proactively saying we're going to overthrow all these things that have gone before.
Yeah.
And
Like us in the movement, compare and contrast.
I couldn't hear you there.
It's like us in the movement. We're activists, aren't we? Compare and contrast.
Yeah. Okay.
What we're being accused of, will be accused of, and how we the activists against.
Yeah, exactly. Thank you for that, Natalie and Emma and Brian. I'm just going to move on because of time. Right. Curtis, can you read this one for me, please? Just got one more slide to do after this, and then we'll end this study. That's if you don't mind, Curtis.
Yeah, sure thing.
Thank you.
The new generation of conservative lawyers whose legal careers began during the advent of the Federalist Society in the 1980s were not tied to the older generation's judicial restraint. Like Emma was saying, where older generations called for judicial restraint, let past precedents stick, let them land. These new kids, these newer generation are saying, no, we need to be active judicially. Sorry, I'm just going to break it down as we go because I forget what I read when it's so long. Now that justices aligned with the Federalist Society were beginning to be placed on the courts, conservatives were now in a position to turn back the Warren Court and Burger Court decisions. In the mid-80s, some members began making an explicit call for judicial activism, what Emma said. The Federalist Society members and law professors Richard Epstein and Randy Barnett were among the first. Flint Bollock, Chip Mellor, and also Michael Carvin were also advocates and formed conservative public interest law firms to argue in the court. These figures made their arguments at Federalist Society events and were influential in the acceptance of a new originalism.
Okay, thank you. Yeah, okay, thank you. Okay. Just trying to think, I've got right. I'm just going to read the next one. Thank you. So these figures made their arguments at Federalist Society events and were influential in the acceptance of a new originalism. Following the election of Ronald Reagan, the doctrine of judicial restraint became inconvenient for conservatives. Now in charge of government, conservatives were no longer in opposition. Therefore, restraint did not fulfill movement conservative goals. With Reagan in the White House, conservative goals shifted from defense, halting and narrowing liberal legalism's advancement, to offense, reversing legal liberalism, and setting precedents for a set of counter rights that appealed to conservatives. Does anybody want to make a comment on the slide? If not, we'll move on. Can somebody read this next slide? Emma, do you want to read this one? We've just got one more slide after this, and then we'll end the study.
This would require overturning precedents and established doctrines, practices considered judicial activism and long condemned by conservatives. Once Reagan was able to appoint judges, overturning decisions such as Roe v. Wade and Engel v. Vital was thought to be within reach. However, it was first necessary to counter entrenched liberal legal doctrine by opening a space and ultimately securing acceptance for conservative legal theory among the legal elites. So, yeah, I might do what Curtis did and stop there a second. So they need to, as we just said before, they need to overturn precedents and established doctrines, which is this process of judicial activism, and which they had long condemned. So now they have to change their tactics. And they recognize that they've got it in sight now that they can overturn Roe versus Wade and other cases they don't agree with. I'm not sure about that one.
Do you know what Engel and Vitale is?
No.
Yeah, well, basically that was a landmark case in the United States in which the court rated that it was unconstitutional for state officials to compose an official school prayer and encourage its recitation in public schools due to violation of the First Amendment. That's what that case is about. Do you want to carry on, Emma?
Okay. So it was necessary to counter entrench. So they're saying that within legal circles, legal doctrine was quite liberal. It was entrenched liberal legal doctrine. So they have to combat that within the educative process, training lawyers, the way the lawyers see their interpretation. As we saw at the beginning of the century, they were all kind of in harmony in how they interpreted the Constitution. And that's kind of entrenched in the system. They had to open a space and ultimately secure acceptance for this conservative legal theory among people who were movers and shakers in the legal world, so the top legal elites. So they had to try and get this new originalism accepted by most of the legal people, or a lot of the legal people. The Federalist Society was central to the development of a fully matured conservative doctrine that could challenge legal liberalism and also provide a conservative understanding of law. So they're trying to mobilize this conservative understanding and get as many people as they can on board, because they recognize they need to have most people in agreement with it to change anything. So they're getting all the most powerful people to agree. Beyond the development of a coherent theory, these new conservative legal ideas had to gain acceptance with the legal community's intellectual elites before judges could reference these novel ideas in judicial opinions. So for order them to carry out what they want to do, they have to get a lot of people on board, or at least the intellectual elites, the top people who educate lawyers, to agree. In general, any new theory in law must be vetted and accepted as legitimate by the professions. So they knew it was going to take time, and they had to get as many people as they could on board. So they started in colleges, didn't they, really, with the new law students, training a group of people to.
ADF.
What's ADF?
Alliance Defending Freedom, training lawyers.
Speak up.
Yeah, I was just saying, I think ADF trained a lot of the lawyers.
Who did?
Alliance Defending Freedom, what used to be called Alliance Defending Fund, they trained a lot of the lawyers.
Is that like a society.
That's
For a
where the new
university.
Speaker of the House of the USA was working. She's come from. So they're like a legal right-wing organization in the USA now. And they're behind a lot of the cases, Hobby Lobby, Cake Shop, one in Colorado, they were in the team. So they trained up a lot of lawyers to think right-wing originalism.
Okay, who would like to, thank you, Natalie. Who would like to read the last final slide, please? And then we're going to wrap up after this.
Hi, Debbie. Can I read it?
Who's that? Is that Mercy?
Melania.
Melania. Oh, hello, Melania. Yes, yeah, go ahead.
Yeah. Judicial activism is the philosophy that justifies that justices should use their position to promote desirable social outcomes from their rulings. To this end, courts that are defined as activist courts will have a large docket. The Warren Court is perhaps one of the most activist courts in modern political history, handling down many landmark judgments, including an end to segregation in schools, rights to legal counsel, right to marital privacy, and the protection of legal rights. The term judicial activism originates with historian and theorist Arthur Schlesinger, I don't know if I've pronounced this correctly, in 1947. And since then, it has caught on in the political psyche and is used widely across the United States. However, the concept of judicial activism has existed for much longer than the term. Thomas Jefferson certainly appeared to believe that judicial activism was in existence when he referred to the behavior Chief Justice John Marshall as despotic. The term judicial activism is now more of a criticism of a court that handed down the rulings. It is often spoken of when a person or group doesn't particularly like a ruling that a court has handed down. For example, anti-abortion groups would cry of judicial activism in the Supreme Court case Roe v. Wade, 1973.
Thank you. So what do you get from this, Melania, before we wrap up now?
Okay, so what I got from this is that the term judicial activism is now used in the modern way as a way of referring to past rulings, like that people feel that the case wasn't treated so fairly according to them. So they'll use that as a way of criticizing prior judgments. Like it has been quoted in the last paragraph of the Roe v. Wade, the anti-abortion judgment. So when people want to refer to that case, if they think it wasn't fair, they'll point to it as judicial activism. And I've also learned that this term, the phrase, is very older than we might think, like it has been used before. So in the third paragraph, there it has been referred that this term has been used before. So it's much older than we might think.
Mm-hmm. Okay,
Yeah.
Thank you, Melania. Does anybody else want to make a comment on this slide before we wrap up now?
Yeah.
Yeah.
Reading this, and especially that last sentence, I don't know, but how can I phrase this? I don't see how you can run away from judicial activism. Thinking of, I'll take Ruth Bader Ginsburg for instance. She goes through experiences. Growing up, she decides she wants to be a lawyer, and then she ascends to Supreme Court, with the idea that no, the America is defunct, and we need proper judges and justices. And so she gets there, and then she says, okay, now I'm going to interpret the Constitution in this way to fix the mess that we're in. So she's a judicial activist. And so it gives the example of conservatives now calling liberal rulings as judicial activism. So yeah, I just don't see how you can run away from judicial activism.
I agree. Yeah, I would agree with that.
Whether it's by conservatives or liberals.
No, I do. Okay, thank you, Curtis.
So Curtis, were you saying that both sides are basically interpreting the law how they want to in their generation to combat the society's evils or issues or problems that they see they're facing currently? It's just whether it's what side of the fence you view those issues from, how you're going to rule in that activism, how you're going to use that activism.
Yeah. I guess that's where I was coming from, because just from conversations with other people, it can be easy, to look at what conservatives do and see them as evil people, wanting to take over America and etc. And look at terms like judicial activism and be like, can you see it's unfair? What is this? But yeah, I was just saying it depends what side of the fence you sit on.
Because they think their side's right, the other side thinks they're right. Yeah. Right.
Just
okay.
one last comment.
Right.
I'm listening to all this and I'm thinking, hey, doesn't this sound similar to what we are doing as the movement? We are biblical activists in one way or another.
Radical.
Just a thought. Just a thought.
Because we're overthrowing established positions, aren't we, Brian? Is that as well? We're interpreting it how we see it for the current generation.
Yeah, definitely. Yeah. Yes, it is right. Yeah. Anybody else want to make a comment before we end the?
Yeah, I have to say though, I think they do. Obviously, we know they break the constitution. They go against the constitution because they're bringing their religion and they're breaking the constitution and that. What did you say, Emma, when I said that to you? You said something interesting.
I just
debunked what I'm saying.
I just debunked it by saying, well, they believe that the constitution is Christian, don't they? That's why they can do that legally. They can bring prayer into schools because we're a Christian nation, and that's that whole article we read about how did the constitution become Christian. So that's how the right will justify that from a legal perspective, that this constitution is Christian, it's written by Christians for Christians. Therefore, this country is Christian, and we can now have Christian prayers. President can call on God. All those things are justified in their minds because they're protecting what God has given them.
Which is not in the constitution. No.
Well, it's true that, Natalie's story we have, which is not in the constitution, but it's true. It was written by Christians, white Christian men who had a worldview back then, which we know about and America's the glorious.
No, I think there's an article 5 or 9. I can't remember that says about not bringing religion into the constitution. Is it the First Amendment?
First Amendment.
Yeah. So what are they talking about?
And the judges are not supposed to be biased regards that either. So yeah, they do say that. Okay, thank you very much, everybody, for participating in that today. My next presentation will obviously be part 3, and that'll be more formative. We're going to bring some lines into the next one. So on that note, I'll end my study. I'll just end the study now. How do I get rid of this now?
Stop share, can you?
It just got share, but I don't know how you do it. Guess I come out of that altogether. I don't know. Okay. If everybody can please kneel. Dear Holy God, as we humbly come before your throne of grace today, we thank you so much, Lord, for the opportunity to present something today. And we hope and we pray as we learn more about the legal system in the United States and how we can have a better understanding of it all, especially how it's going to be brought about. We thank you for everybody who was here today and for their participation in it. So please bless us now, Lord, and the rest of the service. Thank you, Lord, once again for that we can spend precious time with each other and with you. Lord, we give you thanks and praise in and through our beloved Saviour, always to your great honor and glory. Amen. Thank you, everyone.